Good morning, Your Honors. Kathleen McCarthy for Mr. Williams. I would like to start my argument and discuss the required finding in the Rule 25B motions that the defendant's position was improperly denied on both counts. As is clear from the evidence, the Commonwealth proceeded under a joint venture theory. They had to show a causal connection between the victim, Mr. Jones's death, and the defendant's actions in harmony with Mr. Coombs. Based on the evidence as it was presented at trial, I would suggest that the jury was not given information in order to conclude that the defendant or Mr. Coombs was actually involved in the strangulation of Mr. Jones. Specifically, the jury came back with two theories: felony murder and extreme atrocity and cruelty. The extreme atrocity and cruelty was based on the record from a strangulation, and that's what the substitute medical examiner testified to. I would suggest that although there was ample evidence that my client, Mr. Williams, was with Mr. Jones that day, there's absolutely no evidence that he actually strangled him or that Mr. Coombs...
He transported the body afterwards in his car.
Well, there's no evidence as to the time.
Didn't they? He got into the car.
The victim was alive. There was gurgling going on in the back of the car.
There was evidence that there, according to Mr. Williams's statement, that there was use of a stun gun at the location in Springfield, and then the incident, I would suggest to you, moves to Connecticut.
And they dumped the body on the way.
I would disagree with the term that it was actually the body at that time, Justice Cordy, because there's actually no testimony relative to when the victim passed. And there is testimony that he passed via to strangulation, but to actually connect.
Strangled in the apartment, dragged to the car, stunned, put in the car, driven. The car was dumped someplace where the guy died.
I would suggest that that scenario is actually speculative. There was no testimony at all that there was any strangulation done at the Springfield location. There was testimony from my clients.
So he was left in the car, stunned, gurgling, and someone came around and strangled him?
Well, that I would suggest to you, I think the problem is we don't know what happened. We don't know how he was strangled or when he was strangled. We don't know if he was strangled in Springfield. We don't know if he was strangled in Connecticut. And to take it one step further, I would suggest to you that the ligature that is the alleged murder weapon, in this case a shoelace, was found by the detective 3 days after the body was found. I believe it's curious that this murder weapon, so to speak.
Is this a venue question that you're raising?
No, but what I'm raising is as far as connecting it to my client. The murder weapon was not found on Mr. Coombs. It was not found on my client. It was not found in the car. It was allegedly found away from the car with a business card 3 days after the incident, or 3 days after the body was found. What I would suggest is it wasn't found on my client. It wasn't found on Mr. Coombs. There's no indication that they had any connection at all to that ligature. In fact, with the type of investigation that was conducted by Connecticut, albeit the DNA testing on the latex glove, the interviews of Mr. Williams, the videotapes that were confiscated from Fresh Point, his place of employment, I would suggest it would make sense that if they wanted to connect anybody to that ligature, some type of testing could have been done. They did testing on the DNA latex glove that was found in the car, but with the alleged murder weapon, nothing is done to that. And I suggest what that does is it leaves the Commonwealth with a hole in their case because they cannot physically or forensically connect my client or Mr. Coombs to the alleged murder weapon.
Your client went, they traveled from Hartford to Springfield to rob this drug dealer.
There was talk about a robbery, yes.
And they went to his apartment, there was something going on in his apartment, the drug dealer was dragged out.
It wasn't the victim's apartment, it was the co-defendant's apartment, is my understanding.
Where the drug deal was supposed to happen.
Yes, was alleged to have happened.
The robbery was supposed to happen.
Alleged to have happened, and
Okay.
again, not to interrupt.
No, there was no evidence that they planned a robbery?
That they planned a robbery, I would suggest to you, as far as the completion of the robbery, there's no evidence of a completed robbery.
No evidence anything was taken at the time that they dragged his body out and put
I
it in
would
the car?
suggest not, Justice Cordy. In fact, relative to a sum of money, and I think that's really, based on my reading of the transcript, the only thing that can be argued is that my client returned back to work and had a sum of money. Well, the victim's wife testified that, yes, my husband is a drug dealer, we have large supplies of money in the home, but all of the cash that was in the house when I left in the morning was there when I returned home, because I had to count it, because unfortunately she had to make the funeral arrangements. So although the Commonwealth alleges that there is a robbery, I will concede that there does seem evidence that a robbery was planned. However, that a robbery was actually completed, there is no evidence of that. There's no evidence that, and I think the indictment specifies money, cell phones, personal belongings. There's no evidence that my client or Mr. Coombs took anything from the victim. According to Mr. Williams' statement, he traveled from Connecticut to Springfield. He was outside at the time of the alleged stun gun incident, and then the body was put in the car and they were taken to another location. The bill of particulars and the substitute medical examiner testified that the cause of death was strangulation by ligature strangulation, and a fair reading of this record, I would suggest, is blank and does not in any way connect Mr. Coombs or my client to the actual strangulation. So that brings us to the, I would suggest, the directed verdict in Rule 25B relative to the extreme atrocity and cruelty. I would suggest there wasn't enough there to connect my client to that.
Okay,
It's speculative, albeit he was,
Before you go too far, he speaks to the Connecticut police,
yes.
and he says that Coombs and this Hispanic kid, or male, takes the victim out of the house, throws him in the back of the car, that he's still alive, and that they drive him to Connecticut and drop him or drive the car and then leave him in the Save More parking lot.
Yes.
So he says, the victim is alive in my car, and then I dump him, and then he's found dead from a ligature.
Yes.
So either the ligature occurred before or occurred in the car.
Well, again, I think we're speculating for a few reasons. First of all, based on the evidence, which we're all constrained to view here, the evidence is that a stun gun was actually used on the victim in Springfield. The cause of death was not by a stun gun. The cause of death was by ligature. So that takes us really to the next location, which would be in Connecticut, where the body was found, where the shoelace is found not connected to to my client or to Mr. Coombs.
Right.
He said we left him in the car, right?
Yes,
And locked the car, right?
I believe so, yes.
Certainly when it was found, it was locked, as I recall.
I think you're right on that.
So if you leave a helpless individual in a car to die, what is that?
Well, again, I think that the body was not found immediately. We don't know, I would suggest, what happened after my client left the scene and the body was found.
But I guess what I'm saying is if he says, I left the car and it's locked, and then the body's found, and there's no indication that anybody's broken any locks, as I recall.
I don't recall, I don't recall the car being locked or unlocked, but I will go with your scenario.
Maybe I'm wrong, but I thought it was.
I think the car was locked when they found it.
When they found it, that doesn't mean it was locked when Mr. Williams left it there. In other words, again,
He didn't say that he left it locked.
I don't believe he
Okay,
did,
I
but
mean,
I'm
he
not
may not have.
100% sure.
I was just trying to figure out whether it isn't at least a reasonable inference that if he says, I drove the car and I left him there, and then the police find the car, and he's been strangled, that you can't put those things together?
Well, again, I respectfully suggest that the burden is on the Commonwealth, and leaving somebody in a dire situation when the bill of particulars and the substitute medical examiner says it's death by ligature. I would suggest that there was not enough proof to show that my client was in any way associated with the strangulation. Was he with him that day? Sure. Was there talk about a robbery? It seems like there was. However, when you get to the next step, which it is the Commonwealth's burden to prove its case, there's no indication that a robbery actually happened. So for that reason, I think the felony murder indictment should not guilty should enter. And relative to extreme atrocity and cruelty, I would suggest, again, there's no connection to my client in the ligature or Mr. Coombs in the ligature. And I do think it's curious that there was no testing done on the ligature. With all of the DNA that was done on the latex glove and the rest of the investigation.
Is it found outside?
Yes. However, I mean,
How do they know that that shoelace was the ligature?
well, that was the suggestion at trial. It was introduced at trial, and there was testimony by the substitute medical examiner that it would be consistent with a that type of instrument. So, if they don't think it was that was used, why introduce it at trial? I guess
Was it a bootlace or just a shoelace?
it was described as a shoelace, is my understanding, just a lacing. And again, Your Honor, if that was the case, then it would be irrelevant, and why introduce it at trial if they don't want to argue that that was the means employed to kill Mr. Jones?
Well, I mean, the stun gun was applied to his neck,
Yes.
right?
That's
when they got the body in the car.
I think it was before the body was put in the car. My understanding is that, and my client, and this is all from my client's statement, Mr. Williams' statement, that occurred when he wasn't with them. He waited outside when Mr. Jones went inside Mr. Coombs's home. And also, the Commonwealth does allege in its brief on page 53, it indicates that the robbery actually took place in Springfield. And again, I would suggest there's no indication of a robbery occurring in Springfield. So for those reasons,
Springfield is where this all happened.
well, again, I think,
That's where the drug deal was supposed to go down. That's where the people were.
well, when you say it all happened, I don't think it's clear that when Mr. Jones was actually killed. If he was killed in Springfield, if he was killed in Connecticut, was he killed after Mr. Williams and Mr. Coombs left that location? We don't know those things. And respectfully, on a first-degree murder case, I suggest that the Commonwealth should have had a more clearer theory and clearer presentation of the theory of the case and how it actually happened. After reading the transcript, I was left with many questions, particularly how do they actually tie Coombs and the defendant to the ligature? And also, if you think about it, there really was no robbery, so the two theories that were returned, the felony murder and the extreme atrocity and cruelty,
You say there really was no robbery.
there was no,
Rob him.
but there was no evidence that, I mean, in the indictment, it alleges perhaps a cell phone was taken or money. There was no indication that
To rob him, they took him, threw him in a car, stunned him. Apparently somebody strangled him. And your client shows back up at work with what, a roll of cash?
with some money. However, there's no indication it came from Mr. Coombs. There's no indication.
How are we supposed to
I'm
trace
sorry,
it from
Mr.
a drug dealer into your client's hands? I mean,
I'm sorry?
How are we supposed to trace the money?
I mean, actually, it's not the defendant's burden to do that. It's the Commonwealth's.
Draw an inference. You go to rob a drug dealer, you set it up, you grab him, you kill him, you show up at work with a roll of money. I mean, can't the jury draw an inference that it was a successful robbery?
I would suggest to you that that is a speculative fact pattern, because there's no indication, first of all, that the victim had any money on him when he went to that location. There's no indication that my client, if he did have money when he went back to Fresh point, which apparently it seems that he did, there's no indication it came from that scenario. If you would suggest, I mean, the traveling to Mr. Coombs's apartment, there was another Hispanic male there who apparently was involved in the incident. Who's to say that that man didn't then give the money to my client, and that's how he got the money from that third party that was at the location? I would suggest to you that
And this was argued at trial, that there was no
that
evidence
was
of
not
a
argued at trial. No, I'm just responding to your question about
Were
that
there
it was
other
clear there was
possible scenarios as to how he might have gotten the money?
There's many possible scenarios, but again, the burden's on the Commonwealth to prove it.
If I can turn you to the tape recordings in Connecticut, do you agree that they were lawfully made in Connecticut?
I'm sorry, the tape recordings.
The
in
tape
Connecticut.
recordings
The
of the
pen, in the
defendant?
pen.
Interviews
Yes.
in Connecticut.
Do you agree that they were lawfully made in Connecticut?
Yes.
And so what does that say about their admissibility in Massachusetts?
Well, that is a tough case, and part of the problem with this is it was investigated in Connecticut, and then it was prosecuted in Massachusetts, so there were some serious bumps in the road. The point relative to the secretly recording of the conversation, I would suggest that, I mean, in Massachusetts, the only grounds raised by trial counsel was it was secretly recorded. Upon looking into it, I would suggest that since then, there is case law that we don't necessarily have to, under Ashley, tell somebody if a conversation is being secretly recorded. My point in the brief was that there was mention in Ashley of the wiretapping statute, which allows law enforcement to secretly record conversations, but I would suggest to you that it's misplaced and over broadly or used too often, because the kind of limitation on that was for law enforcement to investigate organized crime, not necessarily for all police officers to go out and secretly record conversations that they have with defendants.
These were interviews at the police station, right?
I'm sorry?
These were interviews at the police station.
Yes, they were interviewed at the Connecticut police station, not
Connecticut Police
Massachusetts
Station,
police
by
station.
Connecticut State Police.
Yes, yes.
And is the, because your client also signed a written statement, right?
Yes.
And is there, so both of them, that is a transcript of the recording as well as the written statement were before the jury, is that right?
Yes, and that brings us to the other issue. There was the written statement, then there was Detective Ledger's during the trial kind of synopsis of what the defendant said. Then there was a transcript that was submitted of the alleged conversation. Now, there was an objection to the admission of that transcript because trial counsel believed under Portillo that it should have been the actual words of the defendant himself being submitted and not a transcript of what was said. And I would suggest to you that that does seem to raise legitimate concerns, and particularly in listening to the argument before my argument, where there is some issue about, you know, people listening to an audio tape and picking up on different things. And I think that emphasizes the importance of actually presenting the recording itself instead of a transcript of it, because the transcript might not be actually translated verbatim, and somebody might pick up on something that the person who's synopsizing or transcribing does not. In our case, the trial counsel wanted to have the actual recording introduced, and she objected to the transcript. Now, what then happened was
And the judge allowed in the transcript and not the recording?
well, what happened was there was no redacted recording available at the time that the Commonwealth moved to introduce it. So the judge said, fine, we're going to let it come in as an exhibit, and this was over objection, and then the DA's office can go and edit it or redact it. Then what happened was the trial ended. Trial counsel didn't have time to look at the redacted or to listen to whatever was redacted, and the judge admitted it in without even giving, I mean, trial counsel did not have the opportunity to listen to the redacted disc, and the judge admitted it into evidence, albeit there was no request by the jury to listen to it, but I think that underscores the defendant's problem with the whole situation, because what the jury should have heard was the actual statement by the defendant and the defendant speaking.
Wasn't that what the tape was?
Yes, but they never heard it because it was introduced, it wasn't introduced during the Commonwealth's case. The judge said he would admit it. After everything's closed, the judge says, I'm going to admit this. Trial counsel says, no, it shouldn't come in. It didn't come in through a witness. I haven't even had a chance to listen to what's on the tape or the disc.
But the jury heard the tape, did they not?
No,
They didn't.
they never asked to hear it.
No, I'm sorry, during the course of the
During
trial?
No, they didn't.
No.
Okay.
'Cause it didn't exist, the redacted version didn't
Didn't
exist at
exist.
the time.
They heard the transcript from Detective Leisure, from the detective that was testifying. So they actually heard what trial counsel didn't want them to hear without really the benefit of hearing the...
Sorry, they heard the transcript?
Well, it was
Read
played,
it.
there was a back and forth. The detective read the transcript in a kind of ask and answer
Oh,
fashion.
I see, okay.
Was the transcript introduced as an
Yes.
exhibit?
Yes. And that's in the record appendix,
And this
actually.
was all in English? This was not a
It was,
foreign
yeah,
language?
there was no bilingual problem.
Okay, thank you.
Thank you.
May it please the court, Catherine McMahon, Assistant District Attorney for the Hampden District on behalf of the Commonwealth. This was a partly circumstantial case with the defendant being questioned by the police. Ultimately, as the police gave him details of their investigation, admitting to certain things, but being self-serving about others, but putting his statements, the corroborating video from where he worked, and the cell phone tower information showing the defendant and the victim's travels up from Connecticut to Massachusetts and coming back, and the circumstances of the victim's death. You put it together, and the Commonwealth proved overwhelmingly that the defendant was a joint venturer in the armed robbery and murder of the victim.
Before you get started, am I correct that the evidence at trial was that the defendant goes to his boss and says, I need to take a break to
Goes out to
do
drug deal
do
and
a
make
drug deal?
profit. He told his supervisor,
Who said, yeah, just fine, just mark it down.
make sure that you punch it out. And with the supervisor, he's like sitting outside of the employment. A white SUV pulls up with a black person inside. The victim had rented a white SUV. He was an African-American male. The defendant got in, said, there's my boy, gets in and drives away. The security video at the place of employment shows a white vehicle pulling up, the defendant getting out of the vehicle to go into the place where you punch out. There's a camera at the punch-out point, and the defendant gets back into the SUV and goes away. The defendant says that the victim dropped him off at an underpass close to work, and that the co-defendant, who was supposed to meet him that day looking for employment at the place of employment, happened to pull up in a green vehicle and drove the defendant back to work.
Or drove him to his own car, something like that.
Drove him to his own car, but drove him to his own car on the place of business, at his place of work.
Is there a video of that?
There's video showing the defendant coming back in a green car. The co-defendant had a green car.
And
So-
what's the time gap between when the white SUV left and the green car came back?
I think it's corroborated by the video time of the video, which is before the jury, where them punching out and punching in. And so it's between, like, I think his co-worker said he left at about 8 a.m. and returned, like, after the co-worker had lunch around 12:40.
So didn't he come back and also say, I made a profit?
He
Use the
comes
same
back,
phrase,
I made a profit. According to the co-worker, he's fanning a great deal of money.
Thousands of dollars.
And he gives money to that co-worker and another co-worker, not a large,
Lunch for everybody.
and he buys lunch. Now, the defendant ultimately admitted to the police that he had been contacted by the victim the night before. The victim wanted to buy some drugs. The defendant said that he was in communication with the victim and with the co-defendant Coombs. The cellular phone records corroborate that there's calls back and forth. The defendant said that the victim thought he was going to Springfield in order to make a drug purchase. So that's further corroboration of the fact that The defendant knew the victim had money and a goodly sum of money. The defendant said he knew that even though the victim thought he was going to make a drug purchase, he was going to be robbed. And you can, I think...
At Coombs's apartment.
Yes. And I think based on a lot of the phone contact being initiated by the defendant, and that the defendant didn't just know there was a robbery, the defendant was part of the planning of the robbery. Now, I think it's self-serving on the defendant's part to say that he brought the victim in, introduced the victim to Combs, that there was a third party present, and he went outside. He said he went outside because he knew what was going to happen. He knew there was a robbery. While he claimed he was outside, he said that he heard like tussling and then like bzz, bzz sounds. That's how it's transcribed in the transcript. He says that an incapacitated victim is being pulled out by the two other people. He's put into the back seat of his own vehicle, and the defendant drives him to Connecticut. He's inconsistent about whether the victim was moaning all the way. Initially, he says he was moaning in the parking lot in Connecticut where he left him. At another point, he says that he stopped moaning, at least by the time they got to the ramp in the Springfield area to get on the highway. But according to the medical examiner, the cause of death was asphyxia by ligature strangulation. It takes several seconds for a person to lose consciousness. It takes several minutes of sustained pressure for death to be caused. So
there was a difference, was there, in the cause of death as to the first medical examiner
Evangelisti
and then the second one?
I
was asphyxia.
disagree, and I would refer.
I just let me just get it out. One is asphyxia by neck compression, and the other is
strangulation.
ligature strangulation.
Is it different?
And are those different?
The trial defense counsel asserted that they were different, but she never gave any proof to the judge in arguing against having a substitute medical examiner used. And I refer the court to pages 56, 56 capital A, and 58 of the record appendix. When the defendant's request for a bill of particulars, she notes that it's neck compression asphyxia ligature according to the Connecticut medical examiner. And then that she had spoken to the medical examiner, and he said that no way could a taser or a stun gun have caused the victim's death by asphyxia. She also cited hearsay within a letter from one of the police officers in the Connecticut Police Department to the Hampden District Attorney's Office, where there's hearsay that a police officer had spoken to the Connecticut ME, and he said that taser use could cause the asphyxia. But defense counsel in her request for a bill of particulars said that she spoke to him with her investigator and her co-counsel, and he had said there is no way that the use of a stun gun could cause it. And she also put in her bill of particulars that what he said the cause of death was asphyxia neck compression ligature. So based on this, we don't have the autopsy report and evidence because it wasn't used to cross-examine the substitute medical examiner. We don't have the exact words of what the meaning was, but I think saying that they're different without any proof to trial counsel that they might be different isn't enough to say they're different. And I think reading the bill of particulars, they're not different.
Okay,
So, I'm sorry, go ahead.
can I ask you a question with regard to venue?
Yes.
If the evidence would support the finding that he was stunned in Springfield at the time of the robbery, brought to Connecticut, and rather than let him survive, they decided to strangle him in Connecticut, does that matter in terms of where the case can be brought?
No, I think the physical, the assaultive conduct, which resulted in his death, started in Massachusetts, and it doesn't matter if he expired ultimately in Connecticut. And I think Commonwealth versus Lent is, which is cited in the Commonwealth's brief, is the main case on that point.
Saying if the assaultive conduct, let's just say hypothetically, because I don't know these facts very well, but let's say he's stunned in Massachusetts. Maybe this is what Chief Justice Gants just said. He's stunned in Massachusetts, but the actual act of strangling takes place, but you're saying it's all one part of the same deal? That it's all a continuum? So if the stunning starts in
Well, I think it
Massachusetts,
was more
that's
than a
okay?
stunning. If you take instead of taking it in the light most favorable of the Commonwealth, but taking some of the defendant's things, he was beaten and repeatedly stunned to the point of not being able to walk in Massachusetts. So he was severely incapacitated to the point where he's only, if you take the defendant at his word, only able to moan as he slumped and wedged into the back seat.
Right, but if the cause of death was the ligature and not the beating, does that matter?
I don't think it matters because part of the whole attack on the victim began in Massachusetts. And even though he's ultimately dispatched, and I submit, he's ultimately dispatched before, in light most favorable of the Commonwealth, before he gets into the back seat of the vehicle in Springfield, because it has to be a sustained choking in order, you don't get choked and then moan for a while and then expire.
So do you think if he had everything that you just said, he's stunned and he's beaten, et cetera, and they put him in the car, and then, but there's evidence, this is hypothetical, it's not this case, the evidence is clear that they get across the border into Connecticut, and then somebody takes out a gun and shoots him, and that's the cause of death. Would that still be okay because the beating started in Massachusetts?
I think so under Lent, and this is still, they're trying to, like, a felony murder takes place, you even take in steps people take to escape or...
Was that the only theory on which he was found? No, it
No,
was
two
extreme
theories.
atrocity.
Extreme
Atrocity.
atrocity.
Cruelty
Yeah,
as well.
would it support both the extreme atrocity and cruelty theory, or only the felony murder theory? I know that.
It would support both.
Certainly the felony murder, but
Because with the extreme atrocity or cruelty, more than one weapon was used on him. And by the way, I disagree that the Commonwealth ever suggested that the shoelace that was recovered in the parking lot was the ligature that was used to kill him. The medical examiner could only go with what she'd read in the autopsy report and photographs. She described the ligature mark, but she didn't identify the shoelace as being something that possibly could have inflicted that mark.
Was there any indication of what could have inflicted the mark by the,
She described it as a ligature mark, and therefore a ligature was used, but there was nothing about what it...
But you introduced that shoelace into evidence. I take it was because to make that inference, isn't it? Wasn't it?
I'm not sure whether it was elicited by the trial prosecutor or by defense counsel when one of the Detective Ledger was on the stand. She testified that she collected it from the parking lot out of an abundance of caution, and there was nothing more, regardless of who
was
elicited
the
it.
object in evidence?
Yes, I believe it was, but we never argued that this was the object that had been used to kill him, and I think it's because we had a substitute medical examiner. We wouldn't have been able to do that. She didn't see the body. She didn't examine the body. She didn't make a comparison of that weapon or that object.
That wasn't, the prosecutor didn't argue that in closing or anything.
No.
And the shoelace, I guess, was not sent to see if there was any blood on the shoelace?
There was testimony about certain things that were tested. There was testimony that evidence went down, but there was nothing specific about whether the shoelace was transported to the laboratory and what, if any, testing was done on the shoelace.
what was the relevance of the shoelace then?
You know, unfortunately, and I will go back and check, I'm not sure whether it was the Commonwealth who put the shoelace in evidence.
Ah.
I'm not positive. It may be, and I will check and write a letter to the court.
Okay, but you recall no objection regarding its admission?
No. She testified that, and it was a couple of days after the victim's body had been discovered, that she went to the parking lot after talking to the defendant at his place of employment. She went to the site in the parking lot where the vehicle had been. She saw a business card and a shoelace on the ground there, and she collected them, and her explanation was out of an abundance of caution. And I honestly don't recall any other evidence about the shoelace throughout the rest of the trial.
Actually, I have two unrelated questions, just to finish up on the Lent. Do you think that, could he have also been prosecuted in Connecticut?
I'm not, Lent, and there's a Massachusetts statute that Lent allows it. I'm not familiar if Connecticut has the same kind of statute and case law, which is when there's a question as to where the
That's sort of
killing
about counties, right?
Has the defendant raised this as an issue, venue?
No,
Okay.
not on appeal.
So my other question, it relates to the use of the pen recording. Is that perfectly okay because it was okay under Connecticut law? Is that your view?
My view is that the Massachusetts wiretap statute, which defendant is now relying upon, has absolutely no application to what Connecticut officials do in Connecticut in a Connecticut investigation. There are Massachusetts cases cited in my brief in which federal authorities who have like a federal exception, we don't have to have the organized crime thing that our statute requires. If it's a federal investigation being conducted in Massachusetts, even though a Massachusetts law enforcement person might be doing surveillance or something, but it's clearly a federal thing, even though it's happening within the Commonwealth of Massachusetts, our wiretap statute doesn't apply. If it was a joint investigation or a state investigation, we can't just like couch it under, well, it was okay for the federal authorities to do it. Here, it was a Connecticut investigation in Connecticut. It was permissible under Connecticut law. Applying any kind of exclusionary rule as a deterrence based on our statute doesn't apply in Connecticut. There would be no deterrent value for the Connecticut authorities since they acted lawfully in Connecticut, and there would be no reason to exclude it in the Commonwealth because the Massachusetts authorities didn't do anything wrong. Massachusetts authorities weren't part of this investigation. I suppose in some circumstance where something happens in another jurisdiction that would be impugn our sense of justice, like torture, and a product of torture, we might say we would never allow evidence that came as a result of torture to be admitted in Massachusetts.
Regardless of whether it was legal in some other foreign jurisdiction, we assume.
Yes, but here I don't think
Or in Cuba.
the integrity of our judicial system isn't impugned here.
Okay.
It was lawful.
But the ability for the feds to do this inside of Massachusetts, isn't there an exemption built right into the statute?
Yes.
Okay, so there's no exemption specifically in the statute for this kind of activity done in other state jurisdictions that might end up being admitted into evidence here. There's no exemption for other state, Connecticut officials, New Hampshire officials
Well,
to
no,
do this.
Connecticut has a statute.
No.
Right, no, it's
I'm
just-
saying
it's
in our statute, there is a
analog to
special
the
federal, there's no analog for other
No,
states.
no, and I think if there was something in our statute, it would, because our statute's so tight, that'd be like a big, huge loophole in our tight statute. If it was like, we can't do it, but you can.
Yeah. Okay, now, there's no suggestion, is there, that there was a Massachusetts investigation going on at the same time?
No,
That,
the only thing that the-
Massachusetts got involved later.
Later. Only after Connecticut figured out that the victim had come to Massachusetts and that it likely had happened based on the cell phone and the defendant's admissions, that I think it was turned over to Massachusetts after the testing at the lab, after the interviews of the defendant. The only request that had been made of the Springfield Police Department was shortly after the incident if they would go and do a trash pull at Florida Street where Combs lived. And so that was an assist, just to go and look at the trash, and nothing fruitful came of it, but that's the kind of thing, is like, if there's a federal investigation in Lowell, Massachusetts, and I believe that's one of the cases, and Lowell police are there as just like to conduct surveillance or something, it's still a federal investigation. And here, there was only like one little piece during the Connecticut investigation that involved Massachusetts, and that was them doing a trash pull at the request of Connecticut for Connecticut's investigation.
So we don't have to rely on this case, Commonwealth versus Ashley, this 2002 appeals court case?
No, because the questioning didn't happen in Massachusetts, and it didn't happen, at the time of the questioning, it wasn't a Massachusetts case.
Okay, thank you.
Thank you.